Hello, I'm Robert Bateman, and this is the Privacy Corner, where I talk you through my top 3 picks for privacy developments each week. And thank you, as always, to Privado AI for sponsoring the show. So this week, I'll look at 2 new comprehensive privacy laws in Maryland and Vermont, both highly significant and really change the game for state privacy law in the US. The ICO, the UK's Data Protection Authority, is consulting on data subject rights and generative AI, but they appear to have skirted one of the most important and difficult questions in that area. And the European Commission has opened a DSA investigation into Meta, that's the Digital Services Act, and it's all to do with how they treat their child users. Before I go on, though, I should tell you that I'm in Amsterdam and Berlin and London over the next few weeks, hosting some roundtables with Privado AI, my lovely client. And we'll be looking at how to build a mature privacy framework and the impact of AI and AI regulation. So I'm in Berlin on the 21st of May, that's next Tuesday. Amsterdam on the 22nd of May and London on the 5th of June. There's a dinner and a chat about privacy, what's not to like. Get in touch with me and I'll put you onto the team at Privado if you'd like to come along. So these 2 new laws, one of which has passed, that's in Vermont, and one of which has been signed by the governor in Maryland, and they're both very, very interesting laws, in my opinion. I mean, I am interested in these things, but I'm sure you'll agree if you are a privacy enthusiast. So first up, Maryland, the Maryland Online Data Privacy Act, or MODPA. Not a huge fan of that initialism, but I'm sure I'll get used to it. It has some interesting rules on data minimization, which have kind of been copied by Vermont, but in a slightly different way. So there's a general obligation to limit the collection of personal data to what is reasonably necessary and proportionate to provide or maintain a specific product or service requested by the consumer. So that's the only real grounds, like think of it as the lawful basis for collecting personal data if you're providing a service to the user. You can collect personal data for other purposes if you have the consumer's consent, and the rules on sensitive data are even stricter. So for sensitive data, your processing has to be strictly necessary to provide or maintain a product requested by the consumer, strictly rather than reasonably. And you may not sell sensitive data. That's a flat prohibition. So we've gone from California, where you can sell sensitive personal information, you just have to offer an opt-out, to Maryland, where you just can't do it at all, even with consent. So that is quite a strict provision, and it will be interesting to see how businesses interpret it and ultimately how the courts do. Now in Vermont, remember this bill is not yet signed and it's still a bit of a mess over several different amendment papers and House and Senate bills and so on. They also have a similar data minimization rule expressed slightly differently. So it also has this reasonably necessary and proportionate language, but not just to provide a service to the user, but for achieving a disclosed purpose for which the personal data was collected. So that's quite a strict purpose limitation sort of provision there. You can process the data for another disclosed purpose if it's compatible with the context in which you collected the personal data, and you can process it for further disclosed purposes, but you need the consumer's consent. So anything beyond the original purpose, you need consent. So in this case, that's kind of the only legal basis here. Sensitive data is slightly less strict. It goes back to the old Virginia style model of requiring consent for processing sensitive data. I don't see anything about a prohibition on selling in that bill. Now, the most important thing about Vermont is that it has a private right of action. Now, this provision here is changed several times in the last few days, as far as I can tell. This is from the Senate proposal of amendment to House proposal of amendment to Senate proposal of amendment. So it's getting very, very complicated. And earlier iterations of the private right of action were quite confusing. This one basically says the Attorney General has to write it. So they've passed the buck to the Attorney General, because creating a private right of action is a very difficult thing. You're going to upset a lot of people, whatever you do. So the Attorney General has to come up with something by January 26 and consider what are the gravest harms to consumers, how to protect good faith actors and small businesses from litigation, how to not encourage frivolous claims, and how to target the private right of action at unfair and deceptive acts. So that will be very interesting. They did try to put a private right of action in the law referring to some consumer protection statute in Vermont, but I did look at it and think, well, that doesn't quite work. So I think they've passed the buck to the Attorney General, as I say, and this won't take effect until 2027, I believe. But these are both very serious bills. It was getting a bit boring for a while in Kentucky and just copy-pasting the Virginia bill, lots of states doing very little to change it. Now these two bills come in right before the end of the sessions and really make things interesting again. So the ICO, the UK's Data Protection Authority, is doing another call for evidence on generative AI. This is the fourth in a series, and it's not the last. We've had the lawful basis for web scraping to train generative AI models, purpose limitation in generative AI, the accuracy of training data and model outputs. And this one is about engineering individual rights into AI models. So the kinds of things that the ICO wants evidence on and provides its own preliminary analysis on include the right to be informed, the right to access, the right to delete personal data, and the rights to restrict or stop the use of your information. I take it that's the right to object. You'll notice there's no right to rectification there. Now we know how difficult an issue that is in the large language models. Is it possible to prevent hallucinations or go back and change people's personal data that they deem to be inaccurate? This came up in Noib's complaint against OpenAI a couple of weeks ago. So the ICO says they're not examining the right to rectification in detail because it was examined in their previous consultation on accuracy. But if we go back to that consultation about a month ago, we'll see that it says that the analysis in this document does not cover the right to rectification, but we'll do that in the next one. So it seems to be a bit circular there. The current one says we did it last time, and the last one says we'll do it next time. I think basically it's a hard question and they don't have any preliminary answers, so they have avoided it. So they are looking at mostly the right to be informed here, where people are training or developing generative AI models, and also post-deployment fine-tuning and retraining and that sort of thing. So they look at Article 13, where you're collecting data directly from the data subjects, and you need to give people clear information. A lot of this is quite bland. If you are an LLM provider and you get data from your clients, they are responsible for serving the Article 13 notice to their data subjects. The consultation explores a couple of issues around Article 14. Some interesting statements here. You can't just say data sources are publicly accessible information. According to the ICO, you need to be more specific than that. You need to be very clear about the purposes and the lawful basis. And you should consider resource or expense requirements from the very start. What they're getting at there is you can't scrape a load of people's data and then say it will be too expensive to notify them. You should have thought of that from the beginning. They use this argument against Experian and the Information Tribunal. That was one of the very few things that they agreed with in that case. So the input and output filters idea, this is what OpenAI does, filtering personal data out of the outputs and inputs to kind of uphold people's rights to erase, I guess, or object. Whether that is an appropriate strategy for data subject rights, they're looking for people's views on that. And next up, they'll be looking at controllership in the generative AI supply chain, another very difficult issue. I had a few debates about that in relation to Noib's OpenAI complaint. Are OpenAI a controller when a data subject uses it to produce personal data about themselves, for example? Another tricky issue. I hope that they do tackle that one head on. Lastly, the European Commission has opened formal proceedings against Meta under the DSA, and this is about the protection of minors on Facebook and Instagram. So you might know that Meta is already undergoing a DSA investigation. It started on the 30th of April, so just a couple of weeks ago. That was about political advertising and content moderation. This one is about children's, well, first of all, it's about the allegedly addictive nature of Meta's social media platforms. So they talk about the rabbit hole effect. I'm sure we've all suffered that. You know, you get sucked into a platform and you're clicking away for hours. They're worried about the effect of that on children's mental and physical well-being. But privacy-wise, they are also looking at Meta's age verification tools, which may not be reasonable, proportionate and effective under the DSA, and also their default privacy settings and risk assessment for children. Now, we don't know a lot of details here, but we do know how Meta verified people's ages, and I'll take the words from them directly. They ask people for their birthdays. So this might not satisfy the Commission as an appropriate age verification under the DSA. There are other options for child users, submitting ID and taking a selfie, but they are likely to choose the easiest one, which is putting their date of birth in. But to be fair to Meta, this is not an easy question. Would the other possible options for age verification be acceptable under the GDPR? Asking everyone for ID, using biometric age estimation, that sort of thing. It's not an easy question. So I don't know what the Commission will say, but to be honest, I doubt they'll get a straight answer. And we'll have to keep talking about this for a long time. So that's all from me this week. Do come and see me in Berlin on the 21st of May, Amsterdam on the 22nd of May, and London on the 5th of June. Let me know if you're interested in joining for that. Dinner and conversation about privacy. It should be good fun. And thank you again to Privado. I'll see you all next week.